I'm not.
I mean, I think is he, Jeff, have you gone live? This meeting,
Yes, ma'am.
okay, thank you. Go ahead, Commissioner Scott.
Thank you. Thank you. Good afternoon, everybody, and welcome to, I believe it's going to be the last work group session for the for this non-discrimination ordinance. And I want to start off by thanking everybody for joining in and participating and giving feedback. I'm not sure, Sue Parr is traveling today, and I'm not sure if Morris Porter is on. He lost his mother last weekend, so I doubt it very seriously that he's in. So I asked for prayers for the Morris family. So with that, I'm just trying to see who's there. Can I just get people to go around and introduce themselves, please? One at a time, please.
Ben Hassan, District 6.
Jordan Johnson, District 1.
Commissioner Dennis, he's muted. You're muted, sir.
Dennis Williams, District 2. That's better.
Phyllis Johnson, the Compliance Department.
Odie Donald, Administrator.
Zeta McLean Heyman, Augusta Law Department.
Deborah Poole, Compliance Department.
Nika Jackson, Deputy Administrator.
Wayne Brown, General Counsel.
Matthew Duncan, Attorney in Augusta and President of Equality Augusta.
Okay, well, again, welcome. And I hope everyone received the draft that was sent out with your email last week, this week. And I first want to ask, do anyone have any questions or concerns? What we have brought forth, right? Okay, Mr. Duncan, I see you with your hands up.
Yes, Madam Chair, thank you. I've reviewed the draft extensively, and I think it's wonderful. I think it'd be a great proposal for the city to adopt, and I fully support it as written.
Thank you. Anyone else, my colleagues, do you all have any comment?
No.
Commissioner Scott, or Madam Chair.
Yes, sir.
No, I don't have any questions. I just want to echo what Mr. Duncan said, is that, we have been meeting for quite some time, and it appears that the ordinance, the draft here, addresses what we discussed. The filing fee has been added in, as well as going the hearing officer route, and also leaving out the magistrate court component of the ordinance. I think that this ordinance really gets us to where we were trying to go. So I would echo that. I think we've got a pretty good piece of legislation here to move forward. Of course, there may be other questions, but I would agree with Mr. Duncan that this is a pretty solid ordinance, and it addresses what we were initially concerned about.
Okay. Thank you, Commissioner Johnson. Attorney Brown?
Yes, I believe the instructions that the body gave the law department was to draft. Am I muted?
No.
Okay, thank you. I'm sorry. To draft the ordinance pursuant to Savannah's. Savannah, in fact, does have a referral beyond the hearing officer. it does send the matter to court if the parties are dissatisfied with the hearing officer. And I just heard Commissioner Johnson said he was glad that we went the route of dropping the court and using the hearing officer, and that's not what Savannah had. So the body would need to instruct the law department, which route do you want to go?
So if I could, Madam Chair.
Yes, sir.
Thank you, Attorney Brown, for pointing that out. Now I'm looking at the ordinance now, and I don't see where this would go to magistrate court unless someone would like to appeal to magistrate court. Is that the case? So I guess the question I'm asking is the ordinance, the draft that we're presenting now, the hearing officer would handle the complaints between the person who felt wrong and the business. They would attempt mediation, but it would not go through magistrate court by default as the other ordinances would have attempted to do. Am I understanding that correctly?
No, I'll say this. This is just like the other ordinances. If the party is dissatisfied, they do go to magistrate court. After the hearing officer. What happens here, the hearing officer, after the compliance department has verified that the minimal requirements of a complaint have been complied with, and the elements are there, the hearing officer does handle the case, investigate the case up to a point, then refer the matter to mediation. If mediation is not does not resolve the matter, the hearing officer does have a slightly more formal hearing. And as you will see on page 6 of your draft ordinance, any party adversely affected by the final decision regarding the complaint may appeal to the civil and magistrate court within 14 days of the adverse decision by the hearing officer, so to speak.
Yes, I see that portion, but that portion does not, it's not mandated that they go to MAC court. If you and I felt as though we didn't reach a resolve, then I could file in MAC court as I would do any other time. Like if it was just in any other situation, I could file in MAC court against you.
That is correct. That has always been the case with the prior drafts. Other versions also, none automatically went to magistrate court. Someone would have to appeal or desire to go there.
Got you. Understood.
Yes, sir.
Thank you for that clarification.
Okay.
Okay, Ms. Cool.
Yes, my director and I, we had some questions we discussed before this meeting. It's just a few specific things we want to make sure that we understand. On page 2, where it's talking about the hearing officer could be a competent attorney or a person otherwise qualified with the training and experience. We're talking about a hearing officer being an attorney out of the law department.
Come on
I
board,
believe.
show yourself so you can get involved.
You need to mute yourself.
Attorney Brown, you mute your line. There you go.
I remember in our last meeting, Attorney Brown told me that they felt like that would be a conflict of interest. So we weren't sure if it was an attorney outside of the city or if it's something we would be doing here in compliance. So I am definitely qualified to be doing that, do that for our own internal employees. So we had a question with, because such a big piece of it is involving the hearing officer. So if we could have some clarification on that.
I'm not quite, are you asking whether you could be the hearing officer?
Yes, would it be falling with us? Would it be falling with your law department? Would it be falling with someone outside of the city? That's what we were trying to get a feel for.
The way it reads is either or. And the committee agreed the last time we met that it can be a person otherwise qualified. And so that is why that section was included, because that is what the committee asked for.
But I think what she's asking, Attorney McLean, is whether or not that hearing officer is going to be a Richmond County employee or not a Richmond County employee. I believe that hearing officer will not be a Richmond County employee.
That is correct.
Okay, thank you. Then we had a question on page 3 where it was talking about that the following are not discriminatory practices, and it was talking about the dress or grooming standards, and it stated deemed appropriate in the soul. And we were just wanting a little more clarification. I know in Savannah, they were still in theirs, they talked about like it wasn't prohibited by other provisions of the federal, state, or local law. So we were just wanting to understand that a little further.
Can you point out what section you're in?
It's on page 3, and it was the section where it was talking about the following are not discriminatory practices prohibited, and it was under number 4. And it was talking about adhering to dress or grooming standards deemed appropriate in the soul.
It's number 4 under exceptions.
Okay.
Okay.
All right. I
That
think,
is a typographical error.
yeah, I think I think there probably is a comma that's needed there. Let me read it for the entire body. An employer requiring an employee during the employee's hours of work to adhere to a dress or grooming standard deemed appropriate in the sole discretion of the employer, provided that is reasonable. So what that is simply saying is that the employer still has the ability to determine their dress code for work, provided that is reasonable. Say if an employer says everyone has to wear pants, if it's related to safety, where wearing a dress or a skirt or having your legs out will somehow be detrimental to the operation, so we deem that's reasonable, then that would not be an act of discrimination. So having a dress code will not jeopardize businesses, saying you have to wear a uniform or you can't wear a cap, or we are not going to allow any slogans on our t-shirts because we're a business. We want to be neutral. You can wear a t-shirt to work, but it can't have any words on it. Things of that nature. They will not run afoul of this statute just because they have a dress code, provided that the code is reasonable and is not camouflage for discriminating against a prohibited group.
Thank you. It was the typo that threw us off where we were questioning the what it was saying. And then on page 4, under number 1, in the beginning, it was talking about that you may file a verified complaint. What are we considering verified? Like, we're just wanting to understand what the verbiage of verified is.
Ms. McLean?
You're attesting the truthfulness of the complaint. So it's just like a clause that you would include on the complaint, or assuming that it's an application that you have, because most of the Savannah's application does have a part where you actually sign saying that the facts as set forth in this complaint is true and correct to the best of my knowledge. So that's basically what a verified complaint means in layman terms.
Okay. So we're not determining we're just saying, yes, we've got the paperwork filled out. The form's complete, and then it's going to the hearing officer. Is that correct?
You're muted, Ms. Zena.
Oh, that is correct.
Okay.
Right, you are not verifying, you're not necessarily you're not attesting that what that person put down is true. It's the complainant who's saying, I'm attesting to the truthfulness of what I place into my complaint. that will be a matter of form that compliance and legal can work on to make sure that you have the right language.
Okay, perfect. And another question we had in part 5, where it was talking about the mediation costs. And I understand Savannah does it the same way. I guess the concern I have, if someone, thinks they have a valid charge, maybe they make minimum wage, even struggle to come up with their $50 filing fee, do the affidavit for poverty, how will they be covering a mediation cost if in fact, they are the one that it's not found in their favor?
Yes, the non-prevailing party pays for mediation. I know that Savannah has a mediation center, and that could be the reason why they drafted the ordinance the way it was drafted, because the mediation center does offer fees on a sliding scale basis. And they also have poverty, an affidavit of poverty that they provide for individuals who cannot afford it. I'm not certain if Augusta has that. And that is something that could be looked into.
Okay, because I was concerned how someone could be paying for the cost of that mediation that, might even have a legitimate claim. It just didn't turn out in their favor. And then they're having to come up with all this additional money. And honestly, they'd be better to go to the EEOC and get free mediation than having to possibly bear if their case was accepted.
And hopefully it won't get to that point if it does not meet with the initial requirements. Once it does go to a hearing officer, the hearing officer can make a determination about the matter on its face. From reading the facts, the hearing officer does have the authority to say, well, there's not a case here, so to speak, and issue a report at that point.
Mm-hmm. Okay.
Madam Chair,
Yes.
I think what Ms. Poole is pointing out is something that the body should consider. I'm sure several of you know my point of view about this ordinance. But I do think that what she is pointing out is correct. It is discouraging. The way Savannah has it and the way we are adopting it is discouraging to people who believe they have been discriminated against from using this ordinance. Here you are, you pay a fee to file the ordinance. Then if at the end of this case, it is deemed that you do not prevail, now you have to pay the mediator and the public and the hearing officer. If you prevail, you get nothing. And if you don't prevail, you're financially punished.
Madam Chair.
There's a certain amount of, to put it bluntly, it's very difficult I think if we are being completely transparent about this, I'm not sure this ordinance is very helpful at all to people who will be discriminated against. And I do think, just on behalf of our government, since when we put out ordinances, we should take it very seriously. This is not a motion that we're passing. This is not a resolution that has a very narrow one-time focus. An ordinance is ongoing to govern the behavior of all citizens in the county. We should take that seriously. I think we should not have an ordinance that does not do what it purports to do. Does this ordinance, Savannah's or Macon, does it really fight discrimination? Or is it a tool that businesses can use to say, we have a non-discriminatory city, but this ordinance does not protect the very people that will fall under it? I know there are people who want to push the ordinance. It sounds good, it's good in name, but I do think, given the history of the country and the people who have struggled, I think we should not have an ordinance that's a step above a sham.
Madam Chair.
Commissioner Johnson.
Thank you, Madam Chair. I'm glad that we're having this conversation because this is certainly not our first meeting about this ordinance. Our first meeting, we discussed how to make sure that this ordinance made sense and that it would address the needs of people in our city. That was the first conversation that we had. The next couple of meetings that we had, we were having additional conversations, hearing from business owners, hearing from people who were advocates of this ordinance, from the activism world, from the organizing space. We heard all of these public comments. We tasked to have an ordinance drafted that would make sense, that would, number two, make sure that business owners aren't being gone after from a predatory perspective. So you are my boss, you make me mad, I'm going to go to the city on you. And then vice versa, making sure that businesses aren't doing the same to an employee. And so the goal here is not to get to a point to where, fingers are being pointed or, something to where we can't come back for happens. It is my thought, and it is also my understanding that what we have been going through since April, talking about this ordinance, is that we want to make sure we gave folks the avenue to be heard. Understanding that our goal was mediation, was to get the two parties in the room and have mediation. So I'm going to have to respectfully disagree with our attorney that this ordinance will not help people, because in other cities, we've seen where it has. We have seen that people have opportunities to share how they feel about certain situations that may have happened to them in the workplace. And we have seen to where folks have had mediation and everyone go off with their lollipops and have a good day. That's what we're trying to address here in the city of Augusta. If that was not the case, we wouldn't even have a compliance department that deals with these kind of claims. We wouldn't be at this table. We could have killed it back in April when we started talking about it. So our job on this committee at this workshop is to put out what we're talking about, which are valid points, and make it work and send it to the commission for final approval. I'm sure the commission has questions about this. But at the end of the day, we have an opportunity to draft the ordinance that will actually help people. If we think that this ordinance won't help people, well, let's spend more time figuring out how to make it help people. But to say that we just don't need it, or to say that it's a waste of time, I'm going to disagree with that now. I'm going to disagree with it tomorrow. I'm going to disagree with it next week. Because at the end of the day, discrimination is happening in the city. And you know why we're not hearing about it? Because folks don't have an avenue to share that their discrimination is happening. And the least that we can do is to give them that avenue. So I'm not disagreeing with the premise of, will this help people? What I'm saying is, if we feel on this call that it is not, then we need to figure out how to make it help people from whoever's perspective. When I look at this ordinance, I see something to where somebody have an opportunity to share how they feel about a situation, two parties coming together with someone who is not biased with the understanding that some type of resolve will happen. So we're the sausage makers. And we have to make sure that we're doing it in a way, again, say the same things I said at last meeting, that makes sense to both people who have felt like they've been discriminated against and business owners who may have been, I guess I could say, for lack of a better phrase, misunderstood in what they said or did. That's what we're here to do. And I'll just make that for the conversation. Thank you, Madam Chair.
Madam Chair, this is Mayor Davis. I appreciate the comments that Commissioner from the first just raised. I too share his concern around whether or not this is a valid exercise and a proven conversation to be had. I think we know that there's a sentiment that we should do nothing. Our community, as it continues to evolve, finds itself on the precipice of needing to be not only more equitable, but quite frankly, more inclusive. We are aware cognizantly of a series of events that have happened in our city that brought this discussion forward. It is a worthwhile conversation. It's a conversation that at the onset in April and as late as last year when we first started this discussion was necessary to have because of issues that were taking place not only across this country in the state of Georgia, but right here in the heart of Augusta, Georgia. And so it is in fact a worthy exercise. We've talked about the politics of it. We've talked about what is it going to cost to implement. We've talked about whether or not we're going to have to hire people. We've talked about what's the best department to have it in. We've had a host of these types of, while they're meaningful conversations, they become very spurious and at best, when at the end of the day, we're trying to create a community that's inclusive. Trying to create a community that's not only inclusive, but one that's equitable for all of our residents. On yesterday, unbeknownst to me and my staff, an individual showed up here. They first went to the 6th floor and somewhere along going to the 6th floor and trying to get help and support, someone told them there's nothing the mayor's office can do for you and told them to go on their way. This individual is a transgender individual who was sent to this city 2 years ago from Atlanta. The individual had been beaten and a host of other things had happened, and they were sent here to Augusta. For 2 years, they've been in this community without any sense of hope, any sense of support. They showed up in our office, and my team immediately went to work working with housing and community development, working with Serenity Health, working with the house that they were living in, trying to provide them not only with support, but with encouragement that life can in fact be better. This is why this conversation is important. This is why we're having a non-discrimination ordinance conversation, because they are here in Augusta because they thought they could come here and get opportunity, get a better life. And so for us to, be at this place again, I would hope that we could be more thoughtful. I've spent the last year as a co-chair of the Equity and Inclusion Commission for the state of Georgia's GMA. We just talked about it in Thompson, Georgia. This is our time right now in Augusta to make our city one more inclusive, to put in place tools like this that are not a complete panacea. They're not a stopgap for all issues. There's always going to be EOC available to people. But from a local perspective, it provides us with a more inclusive and engaging and equitable city that gives folks an outlet, a tool in their toolbox that doesn't exist today, whether it's being discriminated against for religious issues, whether it's because of their hair, whether it's because of their gender, their race, or any of these issues. And we don't have it on the books. We started with a draft ordinance that was presented to the commission that was comprehensive of all of the cities that had adopted one up to this point. The chamber weighed in on that, and we offered that to the commission. We've since had a couple of iterations to include the one that's being discussed today. I too share the sentiments of the commission from the first. Let's keep working on it. Let's be thoughtful. Let's listen attentively, and let's dialogue constructively about how we can be inclusive for all of the residents that make up our city. Those that are gay, straight, lesbian, bisexual, transgender, Black, white, Asian, Latino, those that wear hijab and get discriminated and have to take it all the way to EEOC and end up with a federal case. Let's provide tools for them here locally so that they know that Augusta respects them. That's what we should be focused on.
Thank you, Mr. Mayor. Attorney Brown.
Yes, I don't know whether Commissioner Johnson or the mayor misconstrued my comments or not. What I am saying is that as EEO has correctly pointed out, the provisions that are here makes it difficult for victims to come forth, and it put victims at risk. To say the victims pay a fee to file. If they do not prevail, as the law department was tasked by this board by this committee to draft this ordinance pursuant to Savannah. So we have done so because that was the instructions from our last meeting. Savannah's ordinance and our potential ordinance says that if you do not prevail, victim, you pay for the mediator and the public hearing officer. I think that is discouraging to victims. I think that will help people not to use the ordinance that we say we're putting in place to have a less discriminatory city. So I'm thinking that if we are going to say we have an ordinance that helps people come forth to protest against discrimination or what they believe is discrimination, I think they should not be at risk to do it, because we certainly have protective measures in this ordinance for businesses. Businesses, there's no criminal liability. There is no big fee at the end that businesses will have to pay, even if they were found guilty of discriminating. So it does protect businesses and it protects them against false claims as well, because their EEO has the first show and believe that this is a valid complaint in terms of the elements. You have mediation, you have a hearing officer. So I think that is good because businesses need to be treated fairly also. But I just cannot see how it would be the will of the city to tell a person who believes they've been discriminated, pay to file a complaint. If you're wrong, you're going to pay everybody who has been involved to listen to your complaint. That's not even done in courts. People who file complaints do not have to pay the judge to hear it, even though they may have been wrong. It would seem to me that we could have an ordinance that's more inviting and less costly. We don't have a sliding scale. We don't have the center that Ms. McLean has pointed out that Savannah has in terms of sliding scales. So all I'm saying is that if we are trying, as we are sufficiently protected businesses, for the citizen who wants to come forth, like the person who may have gone to the mayor's office yesterday, if they want to come forth, it should not put them at financial risk to be able to say, I believe I've been discriminated against.
Madam Chair.
Madam Chair, this question is for the attorney. I wasn't at the last meeting, so I must admit that my ears are unclear about what the complete direction was. But what I do know is that the General Counsel and staff are tasked with providing us with draft legislation. And that draft legislation, I'm confident, is more than just model it after Savannah, because we had done that when we provided the commission with the early stage draft back in late last year, top of this year. It included all of those things, working in partnership with the chamber, our business community, and members from Matt Duncan's group as well. To that end, my question to you is, if you have concerns that the draft that you've provided us is weighted towards businesses, which inherently have significant protections, how then do you fix this draft that you provided us and make sure that it provides equity to those individuals who, quite frankly, are the ones we're trying to provide this toolkit to? How do you do that as our general counsel, providing us with good draft legislation, which I believe is what the commission is tasking you with, and doing it in a way that's equitable in its implementation, while at the same time not becoming too onerous to individuals who desperately need these types of protections? I believe that's the charge from a drafting of legislation perspective. So how do you do that to fix what you're concerned with?
I will agree that will ultimately be the charge, but we did receive, you weren't present, but we did receive specific and clear instructions that this model was to be modeled after Savannah, period. So that's what we did. I am speaking on today. First, I want to carry out the instructions that we received from the committee because I don't think it's appropriate for us to refuse to do so. So we have done it. But what I am taking here is the privilege or the opportunity to say that putting our ordinance in the form of Savannah turns up to be, to me, a little onerous for people who want to come forth, and I think will be extremely discouraging to them. EEO office handle these complaints all the time. And from an EEO perspective, the one thing you will never do, you will never help anyone with a problem of discrimination if you make it too difficult for them to bring forth their complaint. And Savannah's does, to me, make it difficult. I'm clear this committee is not trying to make it a high price, costly matter. Because this committee did check, well, let's keep the filing fee low. Let's not make the filing fee too high. But this element of the applicant having to pay the hearing officer if they do not prevail, to me is a risky proposition for anyone coming forward.
So why not, again, if we're in the legislative process, why not we strike that language and amend this draft?
Well, that will be to hear from the committee to see if that's what the committee wishes to do, having heard this concern.
Commissioner Johnson, you had a comment?
Yes, ma'am. Thank you, Madam Chair. Attorney Brown, my question is just simple. What do you suggest we do to make this ordinance more equitable? Are you suggesting that we strike the clause that says that fees shall be assessed? Are you talking about the third bullet on the 5th page? Are you saying that we cross that out, that we strike that language? If that's what you our suggestion, I don't think that this body would have a problem with that. But I think that the question that I would have is, what do we determine is, we're talking if somebody files, so I say Ben Hassan, punch me in the chin. I'm just gonna pick on you, Commissioner Hassan, because I like you. If I say Ben Hassan, punch me in the chin, and I'm gonna take it to Mayor Davis's office to solve the issue, and he realizes that I told a complete lie just to hurt Commissioner Hassan because I don't like his glasses, I have to now pay the mayor because I lied on Commissioner Hassan. Is that what clause 3 is saying, or is that totally different? So I guess number one, I'm asking, help me understand what this clause means. And then number two, if in fact there are pieces in this legislation that doesn't get us to a point of being equitable, share some insight with us on what can we do to make it get to the point that we all think that it should be. So number one, what does that mean? Number two, where do you suggest that we go?
Madam Chair, may I say something if you don't mind? Or do you want Attorney Brown to respond?
Wait, I think Attorney Brown, you want to answer that?
Well, I may need a little help from EEO who hear these complaints all the time and what their experience have been in terms of what keeps a person, even from our own employees, from coming forth to complain about some acts they believe is not. But I would think that as a city, well, one thing I think we have discussed and noted that most of these statutes have very low use around the state. And that in itself should be telling to us. But for the little use that is expected, almost everyone on here has said at some point, you know, we have 6 complaints a year. We have 1 complaint a year. And Savannah has had very low use of its statute. And I think embodied in that is this risk, financial risk to the applicants. I would think that if it's going to be so little use, with a city with almost $1 billion budget, why can't we provide for the payment of the hearing officer or the mediator?
Commissioner Hassan?
Yes, ma'am. Can you hear me? Can you hear me, Commissioner Scott?
Yes.
Yeah, okay. Well, first and foremost, this is an interesting conversation. God knows I tried not to say anything. I really did. I don't know whether to commend Attorney Brown or call him a name at this point. I really don't know which one to do. I'm gonna say pretty much when the lady came in from Atlanta, it was an eye opener to me. But I do want to say this, and just to solve it, so I won't belabor the point. I think if you look at number 3, it says the hearing officer's fee shall be assessed to the non-prevailing party unless the hearing officer determines the circumstance warrant cost in some other manner. The answer is already there. The hearing officer has the authority. They can do something different. Now that doesn't give the validity that I don't necessarily disagree with Attorney Brown, but I do say that remedy, I don't see the need to do anything different. Your answer is already the hearing officer knows that this person came in for all intents and purposes, ended up being a pauper. So they know that and they lost. The hearing officer also has the ability to waive that fee. It's in some other manner. That's how I interpret that. It looks like we have an appetite to do this. I appreciate the attorney weighing in on this, but if that is the concern, I think your answer is there. I think, Madam Chair, unless you want to add something else to it, you see from your committee members, can you get it to approve and send it to the commission, to the committee cycle and get it done? I think your answer is there. But on this, I disagree with Attorney Brown at the end of the day.
Thank you. Ms. Poole, did you have something else you wanted to say, or somebody had?
That was me. This is Administrator. I was actually going to make the same kind of thought that the committee on the 6th had, is that, you know, it is a remedy in there, and then we do, if that remedy is chosen by the hearing officer, then we would coordinate that in the same manner that we do other issues that come up funding wise. But I would caution us to take that on in the budget, because while other folks have had, you know, little to no, I guess, engagement in this area, that's not to say that Augusta is. And while we've got almost $1 billion budget, almost every penny is allocated. And so we don't want to make any fiscal assumptions that we don't have to, and it's likely best to follow the best practices of all of these other communities that have implemented the ordinance. So in some areas you want to be the market leader, in others I think it's most appropriate to follow best practices. And I would say, especially from a fiscal standpoint, this is one of those.
Thank you, Mr. Administrator. Do I have any more weigh in on this conversation? If not, Ms. Bonner, do I need?
Chair, Matt Duncan has his hand up.
Okay.
And then after that, I want to get clarification from the commissioner from the 6th about what he said, the point that he was making again. I want to make sure that we all are tracking on the draft.
Yes, sir. Matthew, I don't see you on my screen, so go ahead, please.
Yes, ma'am. Thank you, Madam Chair. I must be off onto the second page of your screen. I do believe that the General Counsel's concerns about having some type of economic barrier is worrisome, just in principle. I wonder if the language, you know, I think the language as is, allowing the mediator and the hearing officer to figure out whether or not the fees need to be assessed is a good position to be in. There might be a way for, like in Savannah, if various nonprofit groups or advocacy groups could work together, and I think it'd be a good idea to do so, to put together programs, maybe a joint program where if parties want to file a complaint but cannot afford to do so, that the funds could be put together to help offset those expenses to mitigate the perceived punishment for filing a complaint. I think that might be a good solution, because it seems to be how Savannah does it, and the nonprofit advocacy community in Augusta might be able to work together to help assist those people that do need that extra help.
Thank you. Mr. Mayor, do you want to go or you want Ms. Poole to make her
Yeah.
comment?
I wanted the commissioner from the 6th to clarify what page he was on and what is he referencing?
Page 5.
Page
number
5.
3.
Page
Page
5
5.
and number 3 at the bottom.
And what are you suggesting, Commissioner Song?
No, what one of the concerns, Madam Chair, may I go?
Yes.
One of the concerns that the attorney expressed was if a person is already filed, couldn't pay the $50 filing fee, or what even if they did, but didn't have the resources if they lost the case to pay the hearing officer or whatever. At that point in time, why would we do that? And the point is that the hearing officer has leverage and understand the circumstances, common perspective, that they can make, that hearing officer has some leeway here in that, so they can make that determination. And so with that being said, I don't think you need to modify anything based on that particular situation. And I was saying that seems to be a major concern. And with that, I can say, since that, if that is sufficient, then it seems to be the appetite in the government to do an ordinance of this nature. Let the chair, if she would decide to do that, to go ahead and from the committee members and take a vote and send it on to the committee cycle if the votes prevail.
Okay, I understand what you're saying. Attorney Brown, I'm not sure if that resolves your broader concern. I think it steps into it, but I'm not sure it resolves the broader concern.
Let me ask this then. If the hearing officer decides that the person made a good faith complaint and the hearing officer says, but I don't find that the business owner was engaging in discrimination, how is the hearing officer paid? How does the commission want the hearing officer be paid? And the mediator?
On the hearing of-
I'd like to make a recommendation, if you don't mind.
Go ahead, Commissioner Hassan.
Yes, it hadn't come up today, but since we're at this crossword, this junction now, I had spoken with Commissioner Scott and looking over it a couple of days ago that we need to probably put about $20,000 in the compliance department strictly for these hearing officer and the mediator, if need be. So you have resources there to take care of that. I think that we're going to kind of stay away from it for budget purposes, but I think at this point you're asking a very valid question. So that's what we do. The commission signed $20,000 over there just for that purpose and that purpose alone. Offset some.
Madam Chair.
Yeah, Madam Chair and Commissioner, Commissioner want to refer to the council member, but if you get a chance, I'd like to also weigh in on that.
Just one moment, Ms. Poole.
Yes, what I wanted to point out on page 4 in number 5, it's saying, in no circumstance shall the cost of mediation be borne by the county. So when I read that, I interpreted, that we were not covering any of this, even, as Attorney Brown said, if someone had this good faith complaint, but then, there just wasn't enough there to find discrimination. So I think we might want to look at that, if we want to make that statement saying there's going to be absolutely no costs borne by the county. And I'm certainly, the first one to be wanting us to have the progressive community, inclusive, non-discriminatory. I mean, this is my passion and what I live for. But what I want to see, I want it to truly be able to help the people we're trying to help. Yeah. And I think that Attorney Brown had a good point, where you're seeing some low levels of participation, it may be a financial thing. As they talked about, like the sliding scale in Savannah, that's wonderful, or if there are cases where we'll say, yeah, we'll cover some of the costs if that's what we need to do for someone. As Attorney Brown asked, why do people not come forward with their claims? Well, a lot of it, it's fear, retaliation. You know, people are living paycheck to paycheck, and, you know, they're truly terrified to lose their job, and can't take on any type of financial burden. So I just think we want to be cognizant of that and think of the, you know, the people that we're truly trying to help.
You may
Madam
have
Chair.
a conflict, but you look at item number 1 at the bottom of it. It says, if financially unable to pay the required filing fee, such fee will be waived by filing an affidavit of poverty on a fund provided by the compliance department. But that there and what Ms. Poole just mentioned, you have a conflict there. So you made you take one of those out.
Yes.
Commissioner Johnson?
Yes, ma'am. Thank you. I have 2 questions, and I'll start in reverse order with the point that Commissioner Hassan just made. The affidavit of poverty, if they can't pay the affidavit, if they can't pay the filing fee because of poverty, I'd imagine they wouldn't be able to pay any fees at the end of the hearing either. So, I mean, that's definitely something that we need to be looking into. But another a question that I have is the way that the ordinance is written and the way that the hearing officer is defined is that the hearing officer is an attorney or a person otherwise qualified. So that could be Ms. Poole, that could be Ms. Johnson. I'm just not saying that's who it's going to be, but I'm saying theoretically they could be the hearing officer. Is that correct? If Ms. Johnson deems that? And I guess that's a question for the attorney.
Ms. McLean, help me out a little bit here, but
Could a city employee be the hearing officer?
yeah, I'm Commissioner, and well, all the members of the body, I'm thinking out loud on this and trying to think through the legal aspects of it. Is, do we want the city to be the ones who's, for lack of a better word, not prosecuting, but judging these cases?
Well, I
Because
think
I would say this, because this would be an ordinance. This is our code. If our codes get violated, can we be the judge? Can we both accuse a person of a violation or have a process for a person to be accused of a violation, and we also set as judge? Can we be the DA and the judge at the same time? Because when we go to court, either law department or an attorney that we designate prosecute these people for lack of a better word, for a code violation. So I'm concerned about whether or not EEO or any Augusta employee really should be the hearing officer or the mediator.
In the other cities, is their model not to have the hearing officer be a staff member?
Savannah has, if I can, Madam Chair, I think Savannah, they have a pool of attorneys, outside attorneys that acts as their hearing officer.
Well, we use that same model. I'm sorry, Madam Chair, but a lot of comments I want to streamline if you would allow me an opportunity to interject.
Yes, sir. Go ahead.
So if we looked at the Savannah model, and that's the model that we want, but again, we are looking at the history of these activities, and they have not produced a ton of folks to come in, whether it's for cost effectiveness, just how the ordinances are being implemented. Either way, whichever the circumstances, when you look at all of these activities, you would not necessarily, I wouldn't advise allocating funds to a specific department. I mean, we would be able to carry it in the same way we do other things by addressing it through our contingency. I believe based on these conversations, we have, now y'all are saying 20,000, but in the proposed contingency that'll be in the budget that I'll provide on Tuesday, I think there's about $50,000 for this activity. And so you would have enough funding to be able to carry that out. And that's the same process that these other entities are utilizing. So I think I wish we would have had these conversations in between now and the meeting, because I think a lot of us have worked together and some have had questions, and this is a good forum, but some of these things have already been accounted for. So the language, I believe, is really good, and the funding source, if needed, is there. But also remember, if you put it in a department, it is there and it's stuck there. Whereas if there's not a use for it and you leave it in contingency, then it remains there and available when needed. And if it is not, you can move forward. So,
Madam Chair.
Thank you, Mr. Administrator. Commissioner Johnson.
Thank you, Madam Chair. I'm going to echo what I said earlier, that I think that this is a pretty good piece of legislation. The questions have all been valid questions, but I think that we're at the point, especially given the point that Administrator Donald just made about the back work that has been done on this in an effort to make this ordinance effective. I think that we have reached a point to where we're ready to send this to the committee process. And when the commission has an opportunity outside of today to ask questions, maybe we'll wind back up in this workshop. But I think that the work that has been done on all sides, the administrator, the commission, the attorney's office, compliance, I think that we're ready to go ahead and have this go to the committee process. So I'm not sure if that would take a vote or if it would just take a consensus without objection. But I would suggest that we go ahead and move forward, sending this ordinance to the appropriate committee to advance the legislative process.
Ms. Bonner,
Yes, ma'am.
do we need to, should it be a motion or consent?
Well,
Let me just ask, excuse me, Ms. Bonner, anyone else want to weigh in the conversation that have not said anything as of yet? I don't know if Pastor Woods from Tabernacle or Morris Porter is on the line, because I can't see every other screen. So
we have a number. I'm glad you asked that. 706-829-7472. Can you identify yourself, please?
Pastor Woods, I think.
Yes, this is Charles Jackson, Deputy Administrator.
Oh, okay. So apparently neither one of those are on, Madam Chair.
Okay, one more time. Do we have any, before you answer, Ms. Bonner, do anyone else have any other?
Madam Chair, may I? This is James Kendrick. I listen intensely, but I'm a little concerned if we all have a feeling that this process is flawed, why don't we go ahead and fix it before you send it to the commission? Because if they're going to get there, they're going to have to do the same thing all over again. And listening to Wayne, he does make the case that we need to do something a little bit different as it relates to these fees. I hate to see us straddle the people of Richmond County with a fee and they don't prevail, and then they got to pay another fee. That really doesn't make a lot of sense to me.
Madam Chair.
Yes. Thank you, Mr. Kendrick. I think Administrator Donald kind of already taken care of that part with the contingency. Administrator Donald, did I hear you correctly with that, about that? That the funds?
I think we had talked about that part going to contingency, and I was surprised that we were talking about putting it in a department. I think that's the part that had concerned me.
Right.
And I think the rest of the process, everyone is right, that you don't want these folks to pay the funds. And I hear Mr. Brown's point, because he's talked about it and made that point and made it clear. But I think we're missing that since we were directed or given that direction to identify a funding source, we did it. The second piece is, I think the writers of the ordinance in other places, as well as he and Ms. McLean, accounted for it. But the confusion is that folks want the language to be a little bit different. I believe that you can clean those things up on the way, but the funds are there. You've got to carve out in contingency. I would not recommend putting it in the department. And if you want to clean up the language, I would trust our legal to do that in between now and it going on the committee cycle. And I think that's just my frustration is because you're all kind of saying the same thing. And you've kind of talked about it and been pretty clear. But again, those pieces are there. And if we need to just make sure they're in the minutes and the notes to make everyone comfortable, and then direct legal to clean up the language, which they've done the last 3 meetings as we've been reviewing this, I truly got it resolved.
Okay.
I agree with Mr. Donald to do that. If they do that, I think that would be fine for as I'm concerned.
Okay. Commissioner Johnson?
Yes, ma'am. I was just simply going to echo you and the administrator there that, you know, some of the concerns that we've raised have already been addressed even before today. So, which is why I suggest that we just move this to committee. Just move it to the committee process. I mean, the mechanisms that we need to make this thing effective are in place. And we just, you know, we don't want to keep going around the mulberry bush, so to speak.
Amen.
Amen. Amen. Amen. Okay. All right.
James Kendrick has spoken.
Attorney Brown, did you have your hand up?
I was just going to ask for, I don't want to be, we can carry out instructions and we have our own opinions, but it's not our opinion. It's this working group's opinion that we want to incorporate on the way to the, back on the way to one of the commission committees for this matter. So I'm asking for clarity. The question is, will we be able to remove the fact that the city in no instances will be responsible for any fees here? Can we remove that?
So he's right.
Yeah, I think so.
Okay.
That would be item 5, right, Commissioner, on page 4.
Page 4, section 5.
Section
Item
5. Yeah, the last paragraph almost said, no circumstances shall the cost of mediation be borne by the county. So it's a consensus that that's out.
Yes.
Fine with me.
Okay.
Okay. And now someone, administrator said, okay, we'll leave this money in contingency. Okay, that's, the money is there, I guess, for paying for the hearing officers. Now, is it the will of this group that the hearing officer, that the person applying is still subject, if the hearing officer so deems, paying for the hearing being assessed a fee if they do not prevail? Is that to remain or not to remain? That's what I'm asking.
That's a very sticky point because
That's
first of all,
number 5, on page 5, number 3.
Yes.
I would go on a limb, Madam Chair, if I could, and say that I think that line may need to stay in. I mean, I think that instead of saying the hearing officer's fees shall be assessed, it should just say the hearing officer fees may be assessed. Because we also give the hearing officer discretion to do what they deem necessary. So, I mean, I think that instead of saying shall and then turn around and saying unless, we should just say that the hearing officer fees may be assessed to the non-prevailing party. You know, in the event that the hearing officer determines the circumstances warrant assessing the cost in some other manner. So I would just suggest that we change shall to may, and then unless just say in the event of, in the event that. I mean, that I would think that would clear up what we're trying to clear up here. Because there will be situations to where someone may not be able to pay. There may be situations where someone was just not honest in their assessment. So I would just submit that.
Okay.
So that
Attorney Brown?
in or out.
Commissioner Johnson, if I may ask him to see what exactly he is saying. You're saying simply leave the language intact, that it may be assessed? Or
Yes.
do we want to put some type of language that says that that indicate that what's the basis for assessment? If they feel that the applicant abused the process, there was no validity, and
Yes, I mean, that was the original goal of them paying at the end anyhow, is that if they were found to have abused this process, if I'm mad at Mr. Kendrick for not giving me a cup of water, and now I want to take him to court for that, I should be held accountable for making Mr. Kendrick's life harder. And I think that's what this section attempts to address, if I'm not mistaken. So I would say the hearing officer fees may be assessed to the non-prevailing party in the event that the hearing officer determines
that the claim is
frivolous or abused, something like that.
Yeah, clearly frivolous.
Yes, sir. Yes, sir.
Madam Chair, Mayor Davis here. The commissioner from FIRST is working on legislative status because he certainly has ascertained the difference between may and shall. And he started crossing the line when he became a little verbose about adding the additional language around hearing officer determining whether it's frivolous or not.
It's the orange tie today, I think. That's what it is.
Okay, well, so I think having stopped at may would have been sufficient.
Attorney McLean.
I just want to point out that that conflicts with language on the 4th page, paragraph 4, where the hearing officer would have already made that determination as to whether or not the complaint is frivolous, blah, blah, blah. So that last half of the sentence that Commissioner Jordan asked to be included, that will conflict with that particular piece. Also, I wanted to point out that the affidavit of poverty that will be a form provided by the compliance department, that we can draft an application that will cover an individual who is indigent, meaning that if that person could not afford the cost of a hearing officer, that decision would have already been determined early on in this process. So we would not need to include that language anywhere else in this ordinance. So I just wanted to make those 2 points.
Is Madam Chair, Ms. McLean?
Yes.
So are you saying, because I don't want to, for the law department to produce a document, so when it gets back to the committee, is this goes straight to the committee, that it did not represent what this body wants? I'm trying to make it clear that if there's a person who files the affidavit of poverty that's accepted, then their filing fee is not only waived, any assessment of hearing officer fee will also would not be applicable. Is that what you're saying?
To the complainant, because I mean,
yes.
The way I read these ordinances, it's assumed that a business would be able to pay the cost of this. I mean, it's assumed, but we want to make it so that an employee who makes minimum wage, let's say, could afford to file a complaint and to go through this process. So hopefully I've answered your question that yes, this would be applicable to the complainant and not for the employer. So if the employer were found to be in violation of this ordinance, then that employer would have to pay the cost of the hearing officer. So to remove that language, there would be no penalty for the employer, because we want to make this ordinance so that employers won't discriminate. So that's how I'm reading this ordinance. So I just wanted to make those points so that this committee can consider that before it makes changes that conflict.
Madam Chair, Ms. McLean, I appreciate those comments that you just made from start to finish. I want to remind us of really what we're trying to accomplish. We want the rule of law to work for everybody. And that's the pauper, the prince, the pope, the pontiff. We want the rule of law to work for everybody. And so to that end, we should not, must not do anything that's onerous, that's, as the Attorney Brown started in this conversation, that's one-sided. The scales of justice must be balanced. And so if we're going to provide an adjudicatory tool for individuals from all walks of life to know that their city cares about them and that they have equal voice and standing, all of these pieces of the language that need to be clarified, we should make sure we're striking. Whether I can pay for an attorney or not does not negate the fact that I still have the benefits of justice available to me called the public defender. So this is what we need to be focused around as we're going to this place and trying to bring clarity to what will be the final draft. I think I've heard before we take it to committee, let's make sure we kick the tires around one more time. And I think, Madam Chair, if it pleases you, maybe one more meeting before we go to committee would be appropriate so that we can see these edits that Attorney McLean has offered, the conversation from the commissioner from the 6th and the 1st, and what Attorney Brown started with. I think it'd be prudent for us to have one more work session like this so that we've got a draft of this broader conversation, that we're comfortable with it. We move forward from there.
Thank you, Mr. Mayor. Work group, is it a consensus that we meet one more time for a final draft so we can move forward? I do know people outside of have jobs and stuff, but I think, thank you, Mr. Mayor, for suggesting it. So can we have can we have one final meeting? Can I see, I can't see the hands. But
I'll relay the results to you, Madam Chair. Mr. Dennis Williams, are you in this working group?
No.
He's good. He's good. Ms. Poole?
Okay.
He's good. Mr. Duncan?
Yes.
Okay, Mr. Duncan is good. Mr. Kendrick?
I'm available, but I would like to make a statement before we close.
Okay, go ahead with Ms.
Go ahead, Mr. Kendrick, with your statement. Madam Chair said.
If I were to make a case against someone and I lose, okay? And at the end, I don't have any incentive to pay the fee if you leave the language in there, right? What recourse do you all have to get your money? I think something it's got to go a little further.
Mr. Kendrick, this is Mayor Davis. I think that goes back to the heart and the spirit of what Attorney Brown was concerned about. And that is the whole premise behind this is to provide a tool whereby which any citizen could come forward and raise a concern and have that concern adjudicated. I use the analogy again of our public defender. There's a reason why the state of Georgia provides a public defender. There's a reason why. And so for us as a local government to do anything less as it relates to this, we then turn this into a conversation about who can or cannot pay. And that should not be the case.
All right, but my point still is though, what incentive have I got to pay after I have lost? I mean, and is it worth to keep that language in there? And I realize I like what Commissioner Johnson said about changing the language from shall to may. That's all well and good. But there is no incentive at the end. If I've lost, I mean, I've lost. I have no incentive to pay you. Do you have mechanisms to make me pay at that point? And it's beyond just being unable to pay. It's just a matter of having the will to pay.
Madam Chair.
Okay. Go ahead.
Real quick, I think that's the balance that's within the ordinance, is that you want to make sure that folks that might be indigent are taken care of and that they are not given an additional burden, or anyone
That's
who
exactly right.
ability to pay. But you also want to leave that stick in there that requires people to pay if they are not. And if they have a false claim, the reason that is in there is that that would discourage people making false claims. Again, I'm not a lawyer by any means and don't want to be, but I do think that if you look at it, I don't know if I would play too much with the language other than those areas that you've already talked about. Legal put together a strong ordinance that balances both, you know, that carrot and the stick. So I think these nuances are appropriate, but some folks, whether we collect it or not, on the front end, you want to just discourage them from making a false claim. And then those folks who cannot pay, the onus in the ordinance is for us to carry that burden for them. And I think from y'all's discussion today, you would be fine with that.
Madam Chair, I love what the administrator just said, and I concur with that. I also concur with, in a moment of brevity for all of us in this interesting subject matter, Attorney Brown, I believe what I just heard the administrator say is that he did not want to be a junior attorney.
No, sir, not at all.
You don't judge a book by its cover.
Very well.
Okay, touche. Touche, Attorney Brown. Okay, we left with Mr. Kendrick.
He had some lawyering.
He said yes, Ms. Kendrick said yes.
Yeah, he wanted to make, so you're good, Mr. Kendrick, for another meeting to review the final
That'll be
draft.
fine. I'll be
Okay.
here.
Attorney Brown, you're good?
Ms. Bonner?
Yes, ma'am.
Okay, Mr. Jordan Johnson?
Yeah, I'm good. I lost connection. I'm back now.
Oh, okay.
I'm good.
Okay, Mr. Donald,
Yeah.
you're good?
Mhm.
Okay. Okay, I think, Ms. Phyllis Johnson?
Good.
Good, okay. Ms. Zena McLean? Payment?
Yes, ma'am. Yes,
You're
ma'am.
good.
Yes.
So, Madam Chair
Yes, ma'am.
and Mayor Davis.
I'm good.
Okay, so it looks like you have consensus for one more meeting to review the final draft before being forwarded to the committee.
Yes, ma'am. And the date, Ms. Bonner?
That's up to you if you want to do it in 2 weeks, or let me grab my calendar right quick, okay?
Madam Chair,
Yes, ma'am.
while she's grabbing her calendar, I just did want to ask a non-controversial point on the page 6, number 6, where a person who feels like they are adversely affected by the decision of the hearing officer can appeal to the civil and magistrate court within 14 days. Many other ordinances have 30 days, which is the traditional time to appeal something. Does this body have a problem with 30 days or is 14 days what is the will of the body?
30 days is
30
being
days,
consistent.
fine.
Traditionally, it's 30 days, but Savannah had 14 days for some reason.
I think 30 days would be fine. Any objection to 30 days?
What page is that on, Attorney Brown?
Page 6, number 6 on page 6. It's almost the last sentence.
Okay,
almost the last
30
paragraph.
days from 14. Okay, that's the consensus. Okay. Okay, Madam Chair, we look like the 28th of October could very well be your next meeting, if that's good with you, at 2. Or you want to, let's see, next week is Commissioner Jordan Johnson's subcommittee, his homeless subcommittee. So
Yeah, the 28th would be fine. If that's enough time,
Attorney Brown.
Brown,
Yes, ma'am.
okay.
Okay.
Any more comments, concerns?
At 2 o'clock in the afternoon?
Yes, sir.
Yes,
Okay.
sir. Thanks, everybody.
All
Thank you,
right.
ma'am.
Good meeting, Madam Chair.
Y'all working.
You did good. You did good.